Thank you. Thank you, Julia, and thank you to the New England Law Review. It is such an honor to be here, and I am grateful to all of you who are participating in this discussion today, including especially the students who are part of this discussion. In many ways, this is a subject in which you are immersed and a subject in which you have particular expertise, so thank you. So the question that animates my book is really a simple one. Who should get to be a lawyer? So the answer to this question defines our profession. This is a question of justice, it's a question of equity, and it's worth our attention. I wrote this book really to address this question. So my plan today is to present some of what's in the book and to convince you of three things. First of all, actually, I'm jumping ahead, sorry. The first thing I want to convince you of is that attorney licensing is in a crisis. And we actually have been for a long time. Number two, we are not protecting the public through our licensing mechanisms. And number three, which might be the hardest thing to convince you of, is that we're changing, finally. We are, this is an exciting time in attorney licensing after decades in which attorney licensing was basically as settled as cement. So, what's the crisis? And where did it come from? The first part of my book is an attempt to describe that. And I want to set that out for you today. So the crisis, the heart of the crisis, is that our licensing system fails to protect the public, but does a very good job of excluding people of color and people without money. Law school can be very expensive. Bar pass rates are down. Bar exams are, at best, outmoded, and they're not sufficiently closely connected to the minimum competence to practice law that they're supposed to be assessing. We all know that bar exam pass rates show persistent, terrible racial disparities. Much of the profession, however, including legal educators, including bar examiners, treats these disparities as inevitable and somebody else's problem, if they're even acknowledged as a problem. Black and Latinx students pay more for law school and go deeper into debt. Expensive legal education without passing a bar exam creates financial ruin for too many, and too many are from underrepresented groups, thus depriving the public of talented potential lawyers. And also thinking about public protection, a person can go hundreds of thousands of dollars into debt, spend 3 years in postgraduate full-time law school, pass a paper and pencil test, and be unleashed on the public to handle any legal matter without necessarily having seen a law office or even having seen a lawyer with a client. Also, related to public protection, the racial and ethnic disparities in bar passage and the fact that lawyers of color are more likely than white lawyers to represent clients of color means that people of color suffer a disproportionate lack of lawyers in their communities. So the questions are, how exactly is the public being protected? And who is the public that's being protected? That's the crisis, and our history explains it. So a lot of our licensing, actually, the things we do today are based on traditions and habits that started in the 1800s. So something that began in the 1800s that we don't do today was so-called open admissions. In the 1800s, many states enacted laws allowing all citizens who were eligible to vote to practice law. But really, of course, in that era, open admissions was actually every white male person of good moral character. And there's nothing neutral, nothing equitable, or inclusive about our profession's historic notions of good moral character. Otherwise, however, a lot in the 19th century continues, or really what we do today had its start in the 19th century. The first bar exams were oral exams, which were basically like interviews to be considered for membership in an exclusive private men's club. a convivial lunch for friends and for sons of members, but a difficult, hostile, impossible barrier for outsiders. Our most famous bar examiner, Abraham Lincoln, once gave a bar exam while he was taking a bath. The bar exams that we have, the written bar exams, also got their start in the 1800s. This is an example from a bar exam. This is an example of a bar exam question from 1897. And for anybody who's studying for the MBE, for example, now, or thinking about the MBE, can recognize that the questions that we have today are really very similar. It's common law, doctrinal questions, except of course this one is a lot easier than what you're going to see on an MBE test today. At the same time, in the late 1800s, many law schools were being established. The alternative had been, and the prevalent path had been office training or apprenticeship. So law school became the more elite path to becoming a lawyer. It required time and money. And so the diploma privilege, giving someone a license to practice law without having to take a bar exam, was established to privilege the law school educated over the office trained. And with a diploma privilege, which was established in a majority of jurisdictions at its height, only office-trained lawyers had to take bar exams. So I have a picture here of Christopher Columbus Langdell, because the part of the history that's actually somewhat shocking to outsiders is that so much of the 21st century legal education comes directly from Harvard Dean Christopher Columbus Langdell, including not just the curriculum, the sort of basic curriculum that we all know, but also Langdell's premise that law schools should not be tainted by too much engagement with the actual practice of law. Langdell's legacy of disdain for practice and practitioners lives on today in the figures that show that most law schools today prefer new law professors to have a PhD in history or economics or whatever over new law professors with any kind of significant practice experience. That's a legacy from Langdell. The early 20th century legacy really is that the alliance of elite corporate law firms and elite law schools took hold, and that continues today. It continues to shape what counts as success in legal education. The first half of the 20th century was important in so many ways in our history of legal education and of the profession. And part of what I have this slide for is to let you know that in the early part of the 20th century, access law schools sprang up in cities across the country. At one point, for example, the YMCA itself had 19 night law schools, including this one in Columbus, Ohio. What happened is that the ABA and the AALS, Association of American Law Schools, the National Conference of Bar Examiners that was new, combined against essentially a common threat, which was these night schools. And so the efforts to improve legal education were designed to get rid of the night schools, to ratchet up educational and accreditation and licensing standards to improve the profession. The escalating standards had the purpose and effect of shutting down many night schools and other law schools that had been created precisely for working people, for immigrants, and for Black Americans. Those accreditation closures and the efforts by the profession to get rid of the, quote, poorer law schools, combined with the Jim Crow legal segregation of the era, left the profession with astonishingly few African-American lawyers. And this is a flat number for the first 40 years of the 20th century, shockingly low number. This is what the leaders of the profession, legal education, and bar examiners wanted and what they achieved. Just as an example, Louisiana rejected every Black applicant between 1927 and 1947. After civil rights activism required state law schools to admit Blacks, bar examiners in Georgia, Alabama, South Carolina, and Mississippi erected new barriers. For example, eliminating diploma privilege after Blacks became eligible for licensure that way. The 1970s deserved a whole chapter in my book because it was a time of activism, advocacy, litigation, visibility. All sorts of different outlets covered the scandal, what was perceived as a scandal, that bar exams lacked validity, that is, they were not shown to be job related, while discriminating against Black applicants. This is a story, or just snippets of one of the stories in the New York Times and a story from Ebony magazine. But at the same time as this activism, the bar examiners were successful in defeating a lot of lawsuits that were brought by civil rights organizations, brought by the NAACP, by MALDEF in California, Mexican American Legal Defense and Education Fund. These civil rights lawsuits were based on constitutional theories and on theories related to Title VII of the 1964 Civil Rights Act. So under Title VII, if you're using an employment test with a racially disparate impact, you have to be able to show that the employment test is job related, that is valid. But the courts held that Title VII did not apply because bar exams are not employment tests. Therefore, validity was not required of bar exams. And this is 50 years ago, bar examiners pretty much stopped worrying about it. The themes of those first chapters about history are that, well, I'd say the most important theme is that good faith is not sufficient. We have wrapped our licensing in good faith, earnest good faith efforts. We continue to rely on good faith, but good faith is really the road to hell is paved with good faith, as far as I can see. So the last part of this first section of the book is really describing our 21st century history. It's another momentous time, almost, or perhaps even more momentous than the 70s. The pressure points include NCBE consolidation, bar industry incursion into legal education, the pandemic and the aftermath of the pandemic, the increasing race-based disparities in the cost of legal education, driven by law schools' misuse and overuse of LSAT scores in granting scholarships. ABA accreditors went from requiring law schools to keep bar prep out of the curriculum to inviting it in, and then enacting Standard 316, which threatens the loss of accreditation to law schools with poor bar pass rates, with predictable renewed pressure on law schools that enroll large numbers of working people and people of color. It's a kind of an accreditation echo of what we saw with the evening schools in the first part of the 20th century. So we were in the doldrums for decades, unthinkingly repeating the rituals of the past, both in legal education and in bar exams. But boom, the pandemic shook us up. Not only did the pandemic shake us up, bring us back to core questions, but we also are the beneficiaries of new research from 2020 that is finally addressing the question, a really challenging, difficult question of what is minimum competence. Attorney licensing is to protect the public. If it focuses on understanding and then assessing minimum competence to practice law, then it is doing a good job of protecting the public. But we haven't even known what minimum competence looks like, or we haven't tried to look at the evidence that we had. But we now do have good evidence that means that we can be doing a much better job of licensing attorneys. The third part of my book is about character and fitness, and basically the history of character and fitness in this country is, as Professor Deborah Rohde said, sordid. And character and fitness inquiries generally reflect the biases and prejudices of the day. So I'm also focused on how to fix it. You know, some of you perhaps are engaged now in the process of filling out that 36-page questionnaire for character and fitness. It's a time suck for students, but it actually doesn't help much, because we do not know how to predict. We cannot predict future attorney misconduct. We should be instead doing a lot more to prevent attorney misconduct. And that's really one of the reasons that we should be requiring clinical education in law school, which is to instill the habits of professional responsibility when future lawyers' ethics are most impressionable. Character is not a question of good people and bad people. Character is a question of what people do in situations when they are not at their best. And we can address character and fitness in so many better ways than what we've been doing. The fourth part of the book is really about what should licensing look like? How do we protect the public? It's an instruction manual, a handbook, if you will, starting with some principles. The handbook is about these 12 guiding principles that I identified. It's about insisting on clinical education in law school. It's about asking more of law schools. One of the themes really of our problems is that we are asking much too much of bar exams and not asking enough of law schools. And I also talk a bit about how to do bar exams better. The 12 principles, some of this is pretty basic and some is controversial, but mainly this is basic. And if we would start with these principles instead of the habits and the rituals that we rely on tradition and history. We need to be much more research-based, much more focused on public protection than we have been. So the first principle is to focus on assessing and ensuring minimum competence to practice law. That should be the point of all of this. It should be the point of what every graduate of every law school has learned. It should be what any additional assessment is about. The research that's most impressive to me about that is the Debbie Merritt and Logan Cornett focus group study that was published in 2020, which told us really what it is what new lawyers do and how they do it. The Building a Better Bar study showed that the lawyers in these 50 focus groups, and these were very, very structured focus groups with set questions, and they lasted for an hour and a half each with 4 or 5 lawyers in each focus group. The new lawyers are, big surprise, using state and local law more than federal law. They engage directly with clients. They also take primary responsibility for client matters. And this might have been thought to be limited to, say, solo practitioners or very small firms, but the members of in the focus groups from law firms of more than 500 lawyers, law firms of 50 to 100 lawyers were also taking primary responsibility for client matters from day one. New lawyers do not have a hard time learning new rules and learning new doctrine. Law school has taught them how to learn new areas of substantive law, but they struggle to learn new skills. And surprise, surprise, they do not rely on memorized rules, and care and preparation matter much more than speed. This study came up with what it calls 12 building blocks, and these are important. And my recommendation really is licensing legal education, any bar exams should focus on making sure this is what new lawyers have. What you can see is a lot of this is not captured well from a bar exam. It's really, this study, I think, very much supports the idea that there should be multiple pathways to licensure, including non-exam pathways. Second principle, eliminate racial, ethnic, and gender disparities as if required by law. We're casual about this. And then we have all sorts of rhetoric of people saying we need to do a much better job of having a diverse and inclusive profession. Well, that starts with better licensing. This is relatively recent data from ABA, this is national data related to JD graduates of ABA accredited law schools. That's evidence that needs to be taken seriously and addressed. We know that bar exams elicit stereotype threat. We know, and psychometricians know, that the closer you get to actual practice, the less disparity there is on racial and ethnic grounds. So that's another reason to be thinking about pathways to licensure that are based on assessment of actual supervised practice. Another principle, license no one who has not successfully practiced law under supervision, preferably in an academic clinical residency. What are we doing? Unleashing people who've never practiced under supervision. That's the rest, every other profession you can think of does this better than we do. And it's going back to Christopher Columbus Langdell and that Harvard model of what makes a great law school and the contempt that he had for the presence of practitioners in the practice of law in law school that explains why we are so behind on this one. We should be licensing lawyers through clinical residencies with or without written exams. We have the tools, we haven't developed them yet, but we can develop the tools to create standardized, rigorous assessments of how a potential new lawyer performs in practice. That's the work that's going on now in many states. And the excitement of this era is that there are states across the country that are working on this. The Oregon Supreme Court has already adopted a plan for to develop a curricular pathway to licensure based on portfolios of work. The Oregon Supreme Court has already endorsed a plan for post-graduation supervised practice licensure. We know that New Hampshire has that as the Daniel Webster program for graduates of the University of New Hampshire. Minnesota is right now has a commission working to develop this exact pathway. Even California is at least considering the possibilities of licensure without a bar exam. And the reason that is important is because this research that we have tells us that there are aspects of what a new lawyer needs to be able to do to protect the public through minimum competence that have everything to do with having understood what practice entails, what the responsibility of practice entails, not what it means to be able to drill over and over to successfully answer, 10 multiple choice questions in 18 minutes over and over and over. So as I mentioned a moment ago, we already have Oregon putting in place a plan for licensing with postgraduate supervised practice. And the reason to do this is that we can identify competent lawyers as well as, or perhaps better than, with a paper and pencil exam. Align bar exams more closely with minimum competence to practice law. The last part of my book is about bar exams and I think the next gen is going to be better than the UBE when it comes in 2026. I don't think it's going to be as good as it could be. What we have had in our bar exam world is we have had wonderful reliability, meaning that consistency, the score means the same thing over and over and over. But as we can say, a clock that's 10 minutes slow is perfectly reliable. It's always 10 minutes slow. What we've been missing with our bar exam world is sufficient focus on validity. That is, are we testing the right thing? Is this really job related and related to minimum competence? And the third aspect for every standardized test is fairness. So we've been superstars at reliability in our bar exams, but weak. High grades on reliability, flunking validity and fairness. The study tells us that new lawyers do not rely on memorized rules, and supervisors of new lawyers are telling the new lawyers, slow down. They want more thoughtfulness. They want care and preparation, much more important than speed. So the whole point of this is to establish competence-based educational and training requirements. I'm not a fan of a straight diploma privilege because I don't think law schools have earned it. But I do believe that law schools can earn it. We can create better legal education by requiring clinical residencies, by having courses or certificates in law office and practice management, by requiring students to have experience in client relationships and negotiation. And I also believe in foundational professional formation courses. I think I've already said this, the competence-based diploma licensure would be closer to minimum competence, less expensive for candidates, and avoid the discriminatory impact of bar exams that we see today. We need to be thinking about reducing the expense of becoming a lawyer. We didn't used to know, but now we know that the bar exam has become a test of resources. These findings are kind of buried in the appendix of a study that was published in 2021. And part of this is not surprising. We all know the world is easier for people with more resources, right? And the world includes bar exams. But what was most interesting here is that graduates who had greater financial resources were significantly more likely to pass the UBE in New York, even after controlling for predictors like the LSAT. Okay, and we know the LSAT has embedded in it socioeconomic differences, right? So even if somebody got exactly the same LSAT, has the same academic credentials, they come to the bar, if they have fewer financial resources, they are less likely to be able to be licensed. That's important to deal with. So coming to the end, or just about the end here, these are mountain goats in going down Main Street in Wales in the summer of 2020. So this is one of my favorite pandemic pictures, because these mountain goats were able to explore new territory that before was hostile to them and unavailable to them because the people left. So we're the mountain goats here, because what happened in the pandemic in attorney licensing is that the licensors had to suddenly deal with how are we going to license people when we can't do what we've always done. And that question of how are we going to license in an emergency turned into the question of, well, how should we be licensing anyway, even when the severity of the emergency is receding. So the new territory for these mountain goats was the middle of Main Street. The new territory for us post-pandemic is back to basics. How should we be licensing to protect the public and build an inclusive, justice-oriented, client-oriented profession? So my pitch here is change is here. It's finally possible. And I'm back to the first question. Who should get to be a lawyer? That's the question for my work, and it's the question I think that will animate our discussion. So thank you very much. I'm excited to be here and excited for that conversation. that we are about to have.
Thank you, Dean Howarth. That was an excellent presentation, and I think you've brought up some really great points that I look forward to exploring further now in our panel discussion. I especially like the image of the mountain goats. It is an unexpected joy to have the space to pursue things that are maybe not traditionally as clear in view. As we move to the discussion portion of the event, I just want to take a moment again to thank all of our panelists for being here. As we go through these questions, I will direct some to specific individuals who may have a particular interest or expertise in that area. However, I would, of course, welcome all of you to respond to any questions or responses as you see fit. So, to get started, I would actually like to pose a question to the entire group, which, based on all of those wonderful points that Dean Howarth just brought up about her book and the 12 steps, there is a push to have law schools, perhaps, and other regulators like the ABA and state bar associations to provide some other form of exposure and experience for law students before they graduate and take the bar examination. What does that push look like? And do we need to change the public attitudes of lawyers and their duties in order to get there? Or is this something that might require legislative action? Perhaps we could start with you, Professor Engler. I know that you have some experience with legislative action and potential ways to move forward on this topic.
So I thank you, Julia. And I just want to say before I start answering how amazing I think Dean Howarth's book is, and anybody who hasn't read it, you should read it. And everyone who has anything to do with the legal profession and licensing should read it. I can't decide whether I think it's brilliant because it's new or it's brilliant because it's really bringing back things we all should know and keep forgetting about. And I think it's both because it's written in such a clear and coherent way. I don't know how you can avoid getting angry, and I don't know how you can do anything other than hear this as a call for action. Julia, I think part of the reason I'm hesitating with a clear answer for you is I think the trap we always fall into when we're thinking about change is that we forget that we need to figure out what we're going to do less of when we're trying to figure out what we're going to do more of. And if any of my colleagues are either in the cherry room or on Zoom, they're going to now roll their eyes because there he goes again on curriculum. But I think the core curriculum, for any of the reasons that Dean Howarth said, is dysfunctional. It's not educating our students in the way they need to be educated. And I think you can't mentally start taking as a given everything that's here and then figuring out what else to do. I think you really have to think about, if the goal is to train people for competence, what would that look like? I wouldn't just give a whole first year to Langdellian doctrinal courses and then have traumatized students who thought they were able to practice law suddenly have a crisis of confidence. I would start with working backwards, as Dean Howarth encourages us to do, figure out what the competencies are that we need to train, and build that in from day one. There's all kinds of literature about a theory practice spiral. As you work in education, you wouldn't assume somebody in the first week of law school would be able to do the things that somebody else would be able to do after 2 or 3 years. But I think you really want to say, if law school is going to stay at 3 years, that's even a theoretical if, I don't expect it to change. How would you build on and teach the competencies now that we're getting a better sense as to what they are? I would also, last 2 things, and then I'll obviously stop talking and let the panelists speak. I think principle number 1 that Dean Howarth has put in, you could modify the wording and apply it to everything that we do. Instead of just saying base every licensing requirement, base every curricular and other decision on evidence and not just hunches, traditions, and good faith. That's how I think you would have to do it. I think the reality is, not for sinister reasons, people who have power, whether it's on a law school faculty, in the profession, in the Conference of Bar Examiners, or even the ABA, are going to be reluctant to write themselves out of that, and they're going to be happier to keep what they're comfortable with and then make changes around the edges. And I don't think that's going to be sufficient for the problem that's been put on the table.
Thank you, Professor Engler. Professor London, do you have any comments you would like to add?
Oh my gosh, so many. This is my favorite topic. Thank you guys very much for having us. Professor Howarth, you know I love your book. I love everything about it and licensure reform. Always happy to discuss this. So I think Professor Engler really has it right when he talks about, we still have these, what I'm going to call strongholds, right, of power that are unwilling or appear unwilling to change. Okay, we've got boards of law examiners, which I just wrote about how they're protected by law from suit. They are protected from freedom of information requests. There's no transparency. How states have abrogated their lawyer licensure duties to a nonprofit, also non-transparent organization that is now purporting to lead the charge and change, right? The next gen bar exam. Now we're going to let the Wisconsin nonprofit tell us what to do. So it's such, I feel almost like it's a hydra. I love the optimism of Professor Howarth's book, and we need to change. But my question, I'm going to throw a question back to the panel is, who's going to start it? Is it going to be the law schools? Is it going to be, are we just going to follow the NCBE, right? That seems to be kind of what we're doing. I know we've got some jurisdictions, you know, like Oregon and New Hampshire, and maybe you said Minnesota, I think, looking at some other, yeah, I think the stronghold of the jurisdictions needs to be hit first before we see big change. What do you think?
Professor Howarth, would you like to take that one?
Sure. Yes. Having been a law professor for over 30 years, I suspect that the resistance to change is staunchest in most law faculties, most law schools, law faculties, right? I have more confidence in boards of bar examiners than I do in law faculties, which is saying something when we're talking about readiness to change. And that's because the law school faculties are driven by a notion of identity and status and prestige, which is not really very closely connected to the competence of their students. It's got other things, and I love being a law professor, but I do think that the law deans and student-focused law faculty need to help shift that culture in legal education. So yes, Minnesota is now looking at a non-bar exam pathway to licensure. We've done some interesting things in Nevada. For example, we have had open book bar exams for the last couple of years. So we have not always used the MBE, the multiple choice. We have we had a commission in Nevada that suggested that what we should have as a licensing package going forward is an early kind of foundational knowledge, either exam or certification of law school success, to opt out of the exam. A little bit like a AP class type opt-out, right? If you've gotten certain grades or you went, you did certain things, took the courses, you wouldn't have to take the foundational knowledge test. Bar exam would be entirely performance tests, and therefore not about memorization, and therefore something that could be given very shortly after graduation, instead of requiring the expense of a couple months of studying and trying to memorize law. And also we'll have the recommendation includes a recommendation for a modest amount of supervised practice that can be done in law schools. The California is looking at non-exam pathways there's a couple other states, Utah also, state of Washington as well. So maybe this is something that we're doing a little bit better in the West, and we need to help those of you who are leaders in the East to bring it eastward.
Yes, the Commonwealth needs some help. And as you can see my tabbed book here, all the red tabs are where Pennsylvania is called out for its exclusionary practices. So yes, please come east.
I feel like you have all touched on some really important points of the stronghold and the sort of power dynamic involved in examinations, and also in the way that this curriculum is formed. With that in mind, I have a question from the audience, which is, preparation over speed isn't really rewarded in the law school curriculum when short exams under timed conditions are generally rewarding typing speed and memorization over the thoughtful analysis that we've highlighted, is a good marker for competency. How do you see the changes in licensing reshaping legal education, pedagogy, and evaluation?
So, Julia, can we put a pause on that question, if you may? Because I think it's important from a DE&I's perspective that we make the connection, and I would be remiss if I lose the opportunity. So, thank you, Dr. Howarth. Forgive me if I mispronounce your name. English is not my native tongue. I'm so thankful for your work, your research, because it felt good, in a sense, to read and affirm all of my suspicions and fears with my legal education career. So I spent my 3 years at Suffolk University more so fighting the legal material that I was learning, because at every turn, every class, every document that is held to be the epitome of the law, there was no representation of me, because they were always talking about, a white man. And so I fought a lot, and I think that is a part of why I, probably no surprise, well, I didn't do so well with the bar. So I took the Massachusetts State Bar 3 consecutive times, so summer, fall, and then spring. And I failed the bar for those 3 times with a combined score of less than 10 points. And so this book really, really spoke to me. I felt seen. And I was also optimistic that those who are following suit, those who are like myself, if you are a transplant from a different country, you overcome learning the language, you overcome adapting to living in these United States and experiencing the world through that lens that is similar to mine. So prior to reading your book, I was reading the work. I don't know if folks, because of the background, people may not be able to see it, but it's called Race, Work, and Leadership. It's New Perspectives on the Black Experience. It's by Laura Morgan Roberts, Anthony J. Mayo, and David A. Thomas. This book did an excellent job in doing research in the legal field here in the state of Massachusetts about the attrition rates. So in addition to all of the obstacles and challenges that a person of color would overcome and succeed in the legal profession, you pass the bar, you get in, there is another tier and another obstacle. Here in liberal Massachusetts, the number of attorneys that are leaving the profession is scary because of issues of diversity, issues of inclusion, issues of acceptance, issues of being the only, issues of not finding enough folks who are either willing and or able to provide guidance, being the only in an office where it's mostly male or mostly white folks. So that is an additional tier to add to all of this. When you talk about the costs of law school, it sank to me. It really did, because I, without getting too personal, still have challenges. And I graduated Suffolk in '02, but because I didn't pass the bar, because I never in my wildest dreams ever imagined that I would be putting in 80 hours for a white man in hopes of someday becoming a partner. That was never my intent. The area of law that I wanted to practice was not in the Northeast at all, which was sports entertainment law. So there were a number of different obstacles that I faced that I never practiced today. Now, I'm very thankful for the legal education that I received. The way that my mind was trained to process, receive information, I don't think any other area could have done that for me. So I love that aspect, but that is the only positive I think that I take from my legal educational experience. And so I would be remiss if I didn't mention, even after overcoming all of the challenges that you have highlighted in your book, there is still yet more for folks who identify like myself, who have to overcome. And sadly, in liberal Massachusetts, if it is this challenging, I can't imagine in other parts of the country what folks are facing. When you think that you've reached the end, you've succeeded, you've achieved this great, great, great measure of success, and then now you have to essentially start retreading in order to build a career. And if, you know, similar to at least the cohort that I had when I was at Suffolk, I met my wife there. She and another friend, they opened up their own practice for similar reasons, because they knew the hardships of getting a lucrative position at any of these law firms. You could, pick one. But eventually, after 7 years, they had to shut it down. And now they're both in academia teaching, because, again, of all the difficulties that have been highlighted for similar reasons. So, that may be another area for you to investigate in your next book, but I would be remiss if I didn't mention that. Thank you.
I think you're
And
absolutely right. Yeah. Oh, go ahead.
oh, please.
No, I think that one of the things the book really shows us, speaks to your experience, Professor, about the gatekeeping function of the bar exam. We are incredibly adept at gatekeeping, from law school, from the LSAT to the bar exam. We are not adept at inclusion. You are absolutely right about that. And I'm sorry, but I felt it too. I'm a first gen student, right? I don't come from a highly polished background. And yeah, there are challenges and we need to break those down.
Julia, I'm wondering if I could respond to the student question that you read, but before I do that, we have one panelist who I know hasn't had a chance to speak yet, and I don't want to go for seconds before someone else gets to go for first. So I'm happy to stand back before I answer it. And I just want to say, it breaks my heart to hear the story that I just heard. And I apologize for any role I and people like me played in it, but it's also a variation on a theme that I feel over and over and over again in counseling students who've come through New England facing one challenge after another. And it's the way we teach, where it's the bar exam. And it's just, once you really read Dean Howarth's book and realize it's actually not for any legitimate stated purpose, and it's harmful, it makes you angry. But I just want to step back and let my co-panelists speak. But I do want one of us to at least take a stab at answering the question.
Yeah, I would just say briefly, thank you so much all for all your comments, and to Dean Howarth for your work. I One of the articles that Julie mentioned earlier that I wrote was a survey I did of 150 Black law school graduates in 2020 about their experience studying for and sitting for the bar, because in the summer I do some bar work, though it's not my primary job. And the stories that I was hearing from students were horrifying. And I really felt like I wanted to play a small role in capturing some of those experiences. And, when I got these responses, I tried to put them in the context of both what was happening in 2020 with regard to the pandemic, and also, police violence and police brutality and protests against those injustices. But really, I found that it was still rooted in what happens every year in law schools and every year to law school graduates. And it had been made particularly worse by the pandemic and by the, a lot of the unrest in the country, I guess I could say. But it really was rooted in the history that Dean Howarth is talking about. And that wasn't just the racial exclusion in access to law school and access to the bar, but it was things like so many of my students, I teach at Suffolk, we have a huge evening program. We started out as an evening program, access to justice. So many of my students have caretaking responsibilities for family members that fall disproportionately on certain groups of students, socioeconomic and racial. A lot of my students have an incredibly high amount of debt, which has overshadowed their educational experience. And they had long commutes, they live with family members, and they were experiencing firsthand higher rates of COVID, higher rates of caretaking, family members in labor and service positions with high rates of transmission, right? So it was this whole kind of perfect storm of things that had been building over centuries in the United States and decades in legal education. And so when someone asked the question earlier, who's going to lead this charge? I hate to say it because the last thing they need is more pressure, but our students are leading it. I mean, they absolutely will not stand for the way that legal education has been doing business as usual. They just won't. I mean, the changes we're seeing to character and fitness discussions of mental health, those are coming from students and recent grads. The advocacy we're seeing around, alternatives to the bar exam, that's coming from recent graduates, so I know, my 3 L's and 4 L's tell me now, just wait till you get to the 1 L's, I know this change is coming rapidly. It's not a burden our students should have to shoulder, but I know that they're the ones who ultimately are really pushing us forward. So I'm grateful for them, and I'm grateful that we all get the chance to listen.
So I'm happy to take a stab at answering the question if I remember it, except I think the questioner may be sad that I'm answering it because I don't know if you're going to like this answer. If I believed the following, which I don't, but if I believed the bar exam was valid, and if I believed that the way we're teaching the courses actually did anything useful to help you prepare for the bar exam, then I could at least understand the logic of having an assessment that prepares you for taking a test the way you would need to do it to pass the bar. There were a lot of caveats there. I think there's a much stronger connection between entering credentials, first-year grades that are testing the same thing, and then bar passage than a lot of the other correlations. And I think there's a very open question as to whether what we traditionally teach in the classroom is doing a whole lot to help people pass the bar. Now, I wouldn't want to just then say, well, how should we teach to pass the bar? Because I'm with Dean Howarth, that we have to change licensing. And I think we have to change what we teach. And you'll all be shocked to know I'm the clinic director at this law school. We have to change the way we teach it. I'm not so sure why we teach contracts the way we do. I would do it with contract drafting. If we have to teach civil procedure, I would probably want to have students litigate a case throughout the course. If we're going to teach evidence, I don't know, I get students who've had wonderful evidence instruction and don't have any idea how to get a piece of evidence into evidence in the courtroom. Even the question of ethics, I think there's an open question as to whether that's better taught by a freestanding course or throughout. One of the panelists earlier used the word infuse. I think there's a whole lot we don't know. We need better data. We have lousy data. So I'm not so sure I want that many time pressured tests, but I also don't want a bar exam that way. And we better figure out how to give the instruction that helps people get their license, which should also tie to having them have hopefully more than minimal competence when they practice law. None of those lines are in place, and I feel awful for the students I teach who are trapped in the middle of this whirlwind of what they're being asked to study and then how they're being tested on it, when it's not clear to me it's going to help them practice law, and I'm not even clear whether it's going to help them pass the bar. So sorry if that answer depressed you.
So unfortunately, with the next gen bar exam, time pressure is not going away, not at all. In fact, our students, our graduates are going to be asked to complete more complicated tasks, but still under time conditions and on a computer, right? So I always want to bring it back to, like, when we think about what's coming, the same problems exist, the same time conditions, the same reliability, instead of the validity question, and also the question of money. How can students afford computers where they'll be able to look at 5 or 6 different documents? So I just throw that out there for consideration.
I would be curious to hear, if I could, Professor Howarth, your thoughts about the MPT. To me, the MPT is one of the only parts of the bar exam, if not the only part, that has any value, to be honest, in the sense of not requiring memorization, requiring true legal analysis, the application of law and facts. And it's a little bit more practice oriented in the sense of being, sometimes a contract or a memo. But maybe maybe I'm just clinging to that because it seems like the one part of the bar exam that makes any sense. But I would love to hear your thoughts about it.
The performance test, either the multi-state performance test or the California performance test, and we do our own performance test in Nevada. To me, those are absolutely the best of the current components of our exams. And also, what I say in the book is that the next gen could be better in certain ways if it has less memorization, and if it has, I think it's a good thing to have more strategy, more kind of trying to be more engaged in the work of actual representation, which is their stated goal. But what I say, okay, so maybe that will be better, but what would be best if you want to have a bar exam is just make it up of performance tests, because one of the fears that I have with the next gen, I mean, there are many, but one of them is it's taken them, 10 or 12 years to develop something. The world isn't going to wait another 10 or 12 years for their next revision, even if they were starting immediately. They're going to have a kind of a structure which has a very, very complex sort of testing design, and they're going to be stuck with it for a while. And one of the advantages for me of the performance tests, even though they're not yet what they could be, and they can be too speeded as well, but with the performance test, you're actually doing something that is mimicking practicing law. So one of the ways that we know that current bar exams are not testing minimum competence is that none of us could pass them, right? And if it really is minimum competence, and if we are competent lawyers, we should be able to pass them. And I'm confident that I could actually pass a fair performance test, an exam that was a set of performance tests, because I would be given the library. I have the skills, I have the methods, I have the threshold concepts. I would be able to figure it out. I have no confidence that I'll be able to pass the next gen bar exam. And so I love performance tests. I think that they can be expanded, and I think they're flexible. They could be, there's some nimbleness with it. And one of my favorite quotes from the Building a Better Bar study with the 12 building blocks was one of the new lawyers in one of the focus groups said on her first day of, I'm not sure why I think it's a woman, I think it was a woman, on her first day of practice, she got her first assignment from her supervisor, opened it up, looked at the file and said, OMG, it's just like the performance test. So that's what bar exams should be.
I totally agree. And I will say, so I tell my students all the time, at my first job, I came into my job, I was a legal services immigration attorney. No one had been in the position for 2 or 3 months. The cases had just been sitting there. There was 83 cases, and I had never done immigration law. And so I tell them, it's not about what area of law you go into, it's you got to sit down with that file. And we all know that competence, right? We talk about competence, like 1.1, the rules. Competence means knowing what you don't know. And it means knowing what help you need and where to get it, right? And so I say, whatever that was in that file, I sat down, I made a list of the people involved, I made a timeline of the case, I made a list of the documents, right? That's an MPT. And so, that's the MPTs are kind of the only, and I'm very upfront with students that that's the only decent part of the bar as I'm concerned, but I say, that's what practicing law is. It's not sitting down and memorizing, it's saying, here's what I have, what do I need to know, and how do I find it? Right. And that's competence in the model rules, that's competence in practice, that's competence in all these different areas. And I agree with you. The MPT kind of has some of the core elements of that have the potential for expansion or some sanity in testing.
And going back to the question about assessment in law schools, I would love to see performance test exams throughout law school. I think it's a really good idea to test, and this might sound cruel, but I don't think it is. It's a good idea to have some of the testing be about and on the basis of materials that you haven't seen before, right? Because it's really about methods, about bringing the skills of careful professional reading to be able to understand what's important. And that's what I want in a lawyer when I'm a client. We can do that so much better in law school than what we're doing now.
I love talking about, these different sort of methods and ways that we could potentially do legal education better. And these competency tests, I think, are a really great place to start on like a practical sort of nitty-gritty level. How do we think that post-school residencies or clinics would be overseen, or the different sort of measures of competency and performance? Would they be overseen by law schools? Would they be overseen by employers? On a practical level, how would we make those assessments, and who would be doing the assessing?
So I can speak to what is being developed in Oregon now, which I think is the furthest along, at least with a scalable kind of project. New Hampshire is the oldest sort of practice-based, competence-based licensing, but it's a tiny little program, and it's too small. It's like 20-something people every year. But what they're doing in Oregon, I think, has the capacity to be scalable and available to every graduate. And what that will require is it will require essentially a partnership between clinical faculty and bar examiners. And like every other kind of professor, my clinical colleagues and I love our independence. And we love being able to be in complete control of our classes. And so the adjustment that we have to make as clinical faculty who have a larger role potentially in licensing than we do now is to be able to adjust to having at least some kinds of standardized work product systems that we don't have now. And so, for example, in Oregon, they've already developed, because it's already, it's kind of in place already and being developed already. They have standard rubrics for assessing how someone does a client interview. They're developing standard rubrics, really kind of a check form for a negotiation plan. So what needs to happen with a little bit of adjustment from the clinical faculty is to be able to use some of these standardized programs and processes, and then have a system in which the students can put their portfolios into a system and have those portfolios of sometimes redacted work product be able to be reviewed by the bar examiners. So bar examiners are, so the clinical professor isn't saying this person has passed the bar, has passed this portfolio alternative bar, but they are saying they did this thing competently. Here it is. Here's my assessment of it. It's part of the whole portfolio that goes from the candidate to the bar examiners. Then the bar examiners are making an ultimate decision. What's correct about this educationally is this process begins during law school. You don't wait till the very end and then get a thumb up or a thumb down, but instead the candidate has the opportunity to have the materials that they've developed be reviewed while they're in law school still. And if a bar examiner says this was an incoherent negotiation plan, I couldn't make sense of it, you had not yet satisfied that requirement in our licensing pathway, well, then they have another opportunity to come back and do it again.
Julia, can I just say one thing, and maybe it's a question for the dean? As I read, I think this discussion is jumping off from chapter 12 on clinical residencies. And the only sadness I have with the way the question was framed was it was focused on postgraduate residencies. And I think it's a mistake to put all the eggs in those baskets. I think it runs the risk of delaying. I think it runs the risk of increasing costs. I think it runs the risk of all the kinds of biases that we're talking about. I think there's wonderful things that can be done, but I don't think the starting point should be to focus on postgraduate. I was once at a conference where somebody from a very elite law school took the position that the way to deal with the cost of law school was to have lower tiered law schools go down to 2 years and then have some kind of clinical residency afterward. And I said, I might consider that if we would get rid of the first year, but not the third year. And the room was stunned. But my point was, you're going to cut out all of the clinical and externship, and you're going to organize it around the same old series of doctrinal courses. So I just want to, I know this is a harder sell, but I want to keep on the theme that we can't just keep what's not working as is and then add things. I completely agree that we cannot unleash people on the public unless they've had this type of residency, but I think it's got to be baked into what we consider appropriate legal training.
Yes, that's exactly right. And the Minnesota plan, as I understand it, is moving first with a curricular-based pathway, and then they'll have some kind of a, I think, second in time, a potential postgraduate pathway. For me, the postgraduate pathway is just an interim measure while we get the law school, make sure that every possible lawyer in the country is at a law school that can deliver the clinical experience during legal education. That is, that's just part of equity, access, and fairness. But there's no question that this should happen in law school. People are already paying for something that should be, that should include that. That's number one. Number two, it's even if a lawyer, we can all think of lawyers who are just lovely people, who are unbelievably wonderful mentors and teachers. So if you sort of posit the best possible supervisor postgraduate out in a law office, in the public defender's office or in a law firm, the pressure of the work there is an inhibitor on being able to really allow the student or the new potential lawyer to be leading the representation. Because we all know that, at least I would say, that part of the clinical teaching method is to slow everything down, to require every clinical student who is taking on the responsibility for representation has to learn to first make a plan before they do anything, and then afterwards, and then do it and then reflect about it. That's slowing it down, and it's very hard for even the best mentor, teacher, practitioners to have the space and the time and the ability to slow things down, to create the opportunities as well as they can be created in legal education. So I'm all in favor of this being a loss baked into, as you say, infused into the legal education that we offer.
Just want to take a minute and say thank you on behalf of Professor Schendel. She had to hop off to teach a 6 p.m. class, but she will be missed, and I've really appreciated that she was here. So I just wanted to take a moment to say thank you to her. And also, I think you guys are bringing up such excellent points about timing. And I think timing really is essential when we're talking about education, because it is such a scaffolded process. So I'm glad that you're highlighting that. Mr. Pierre-Louis, I have a question specifically for you from the audience, which is, as someone who has lived through the failures of the bar exam, do you think that these competency-based licensings would have helped you or paved a different pathway to the career that you were seeking? And if so, what do you think is missing or would be helpful for others in similar situations?
So I think the answer is yes, it would have. And I say so because I have a friend of mine who also attended UMass Amherst, attended Suffolk, has been practicing and working, well, not practicing, but working in law, but still has yet to pass the bar. After numerous attempts, very well capable, does great work, except he cannot go and represent any clients because he just does not have that credential as a person who passed the bar. And so he is still able to do all of the things that we talk about. He drafts and works with folks. So a lot of the transactional stuff, he's great and excellent at. But for whatever reason, now I think it's becoming just a mental hurdle because of the many failures that he just simply cannot pull it together. Now, being older, having more responsibility, less time to invest into studying for the bar, it's a point where he's just like, I'm trying to figure out a way to sustain a lifestyle and a career without this one particular hurdle, because it just has remained steadfast that no matter what he does, he just can't pass the bar, but he's well capable of doing the work. So I think, that person, he is a living example that, having the opportunity to do the work, to learn, because he did learn from an attorney that was practicing even when we were in law school, that took him on, that was a mentor of his and allowed him to do some work, to do some of the transactional stuff. And he learned how to do a lot of that during his career, but just simply has not successfully passed the bar. So.
And I'll just add to that, one of my motivations for doing this work, for writing about bar exams, for thinking about bar exams, and then writing this book is that I have had students who I would hire to represent me who have not been able to pass a bar exam. And I have had students who I've taught at a lot of different law schools. I have taught students who could probably pass a bar exam without actually going to law school because they're so good at test taking, who I would never let anywhere near anybody I cared about. So that's my motivation.
I really appreciate both of you for sharing, these stories. I know that the bar exam is something that it is a really significant hurdle for a great deal of people. And I'm glad that we're really pointing to ways that we can do it better and make sure that competent people are out there and able to practice as they desire to. And I think that this is, I don't know, I'm almost lost for words actually at this conversation, because I do think it's such an important topic, particularly where there is so many other hurdles on the path to law school, and there are all of these biases that you have aptly mentioned and pointed out, sort of baked into either the LSAT, where it's resources of time or money or social capital. So I think with that in mind, do we think that implementing more of a residency requirement in either legal education or postgraduate as a method of licensure, will that help reduce the exclusion and bias, or are these methods still susceptible to those risks?
So I can do a quick response, and that is absolutely every possible. I mean, we live in a world in which access to power is not neutral, right? So every possible method of getting the access to the power of a bar license is going to have freight with it that is that perhaps is based more on exclusionary history than on inclusiveness or the values that we might at least prefer to endorse. So, for example, just in our history, we know that I know that supervised practice is good for the public. I also know that Professor London's great state of Pennsylvania earlier, in the mid 20th century, decided to adopt a supervised practice requirement precisely for the purpose of preventing Jewish men from becoming lawyers. Okay, so that's on the record of bar examiner notes. We're using offensive language. So I'm all in favor of apprenticeships and supervised practice, but I also know they can be misused. It's being misused now in Delaware as a hurdle. So you not only have to pass a bar exam at the highest or close to the highest cut score, you also have to find yourself a supervisor for whom you will work for, I forget how many months. I think they just reduced it from whatever it used to be to something less. That's designed. It might not be what they would acknowledge today, but that was designed in order to keep the Delaware bar elite. And so that's the right kind of a process. Same issues in Canada. Canada has for a long time had an articling system in which everybody has to practice law for a year under supervision before they get their full license. The articling system in Canada and also in South Africa, where they've had the same thing, is rife with exclusionary aspects because their traditions, they set up articling at a time when they were still having these racist, sexist notions of who's a proper lawyer, who should get to be a lawyer, right? So the system was baked in to be about who you knew because you needed to have a job to be able to get that part of the requirement. So the access to articling has been a significant problem. And then the other issue that is, I think, goes right to your question as well, Julia, is the power imbalance when someone's in an articling situation is quite serious because think of it. We know there are issues of harassment and abuse in any kind of power imbalance, even in professional setting or workplace setting. That's true and been documented in articling because the boss isn't just your boss. The boss is the person who's going to determine also whether you get your law license, even after you graduated from law school. So there are enormous potential problems, even with something that has the promise of making better public protection. That those issues of abuse are also partly why I am so much in favor of getting the supervised practice done in law school, where there are structures and systems and more transparency, more possible variation in choosing what courses you're going to be taking, what clinical courses you're going to be taking, and therefore you don't have the same, we know there's power imbalances in legal education. Oh my goodness, every student knows that, and every professor should too. But we also can do a good job of building in systems to be able to address it. So for example, in Oregon, their system, their supervised practice pathway has a ombudsman person built in, so that there is not just a sort of a vetting and a set of principles for the supervisors of the supervised practice, but there's also a person as part of the program whose job it is problems with supervisors.
Julia, I just would add a PS that I would go back to the guiding principles, because I think the data is hard to escape, impossible to escape, that the current system is not working, and it stands to reason that the alternatives would be better. But I think any of the experiments that we try, any of the new programs, have to be rigorously evaluated. And if some of them fail by the same standards that these are failing for the reasons the dean just said, we can't just cling to it because that was the change we made and it's got to work, darn it. I mean, I just think we have to be really thoughtful and intentional about this and try things out and track the results.
I agree. Oh, go ahead. Go ahead.
No, I was going to allude, speaking to that, so I could speak from example, though it's not specifically this, but something similar. For me, when I decided to go to law school, I quit my job. I gave up my apartment. I moved in with my brother. So by the time spring semester of first year law school came in, folks were talking about internships, doing this, doing that, and I'm like, oh my God, I felt like I got caught with my pants down. But I couldn't even volunteer my time because all of the quality internships were gone. And B, I needed to have an internship where I had to get paid because it was a part of survival. As a young professional, my brother could only do what he could do. He had a wife and young children. And so when we talk about these programs, we have to think about equity because some of my fellow students, their internship were already in place because they're going to work for this uncle, or they're going to work in the office of their dad or grandfather, or other connections that they already came in pre-established where there was not that much effort, and their grades really didn't matter. So the others, and the very few attorney, or the one or two that I knew, they were solo practitioners. They couldn't afford to pay me. They couldn't afford to take the time to teach me and mentor me, to teach me some of the things that I needed to learn. So speaking of these clinical, we really, really have to have some intentionality when we talk about equity. If we are trying to move the profession forward and making these things inclusive, there's a lot of things that have to go into consideration. And people in my situation certainly matter. I was not one of those folks that went directly from undergrad. I worked professionally for 4 years. And so I knew what it meant to not have income and to have to sacrifice, but yet to not see a return after 3 years. That was disheartening. That was very disheartening.
So can I just jump in and say something that gives me hope? And it's building off of something that Professor Shendell said before she left. I have so much hope in the new generations. The fact that this law review, you guys are having this symposium, we are having this discussion. I hear it in my professional responsibility classes. Students today are not going to accept the same inequities that have been perpetrated in the past. I mean, I get chills just thinking about it. I mean, here you guys are talking about this and making this a reality. And it's true. Should you bear the burden? No. I think you can see you have plenty of allies at the law school level. We'll find more allies in the state level, right? But I think you guys are to be commended for thinking about this. And I just want to say I appreciate the work and the thoughtfulness that you're bringing to this, because you will be the change. You will.
Thank you. Oh, Professor Howard.
Yeah, let me
Yes.
just add on to that, which I completely agree with. In addition to the burden of being the change and the opportunity of being the change, it's also, I think, potentially a burden for students who are thinking about their own dreams and who are in law school now and are thinking about bar exams and how they're going to handle the bar exam, to figure out how to, in a balanced way, confront the problems of licensing without having that undermine motivation and undermine strength and undermine confidence. I think that's a really, really big challenge. Now, it is absolutely a surmountable challenge. I believe knowledge is power, right? I think students I know are much too smart to get hoodwinked into thinking that that the character and fitness 36 pages makes sense and is worth it. You can see, right, that it was designed for somebody who's young, who went right from college, who's always lived in the same place, has had very few jobs, pretty much had done very little. That's who it's designed for, and who's had great stability in their life. Okay, so the rest, everybody else who's had a more complex life, who might be older, who might have had lots of residencies, can't even remember all the places you lived. You can't remember all your jobs. People who've been arrested, like a third of our country, people who have convictions, even people who have more complicated lives. You can see that the system was not designed for complicated lives. The system was designed for basically a bigoted ideal, right? Of a healthy, young, straight, if they even were thinking about sexual orientation, Christian man of means. That's what who the system was designed for. And if you're not, even if you are that now, and you've just had a more you haven't always had your parents taking care of you, the system wasn't really designed for you. So our students are smart enough to see that, right? And then the question is, how do you make yourself go through this process without losing something of yourself in it? And I think that's a trick. And I know that it's a hard task that is worth figuring out how to do it. And the answer is that the answers are different. And I know Professor London knows a whole lot about this. The answers of how to make that balance, to be able to bring to yourself the confidence for success, is different for everybody. But for some people, it's about figuring out that it is a game and figuring out how they're going to win the game. For other people, it's about giving yourself space to remember why you're doing this, right? Is it your kids? Is it your family? Is it your ideals of justice? Because you have to be able to have a system, really, to remember why you're motivated. I think that's especially true for people who can look at this disparate bar results and find that really discouraging. And the answer is, it's not just discouraging, it's discriminatory. That's right. It's not right. And we need lawyers to fix it. And we need you as a candidate to figure out how you are going to get your power to be able to help fix it as a licensed attorney. It means figuring out how to Give yourself the messages that you do belong here, even when there's so many messages that you don't belong, because we know, right? So educators, social scientists know that when you have confidence that you belong, in spite of all the messages that you don't belong, your success is going to be that much greater, right? The psychological, the barriers here are intense, but also the power to overcome those barriers is also intense. And I want to make sure that we give that message as well, because the profession is being led now by lawyers, licensed lawyers, who nobody gave a shot to, and they have overcome all the barriers that were placed in front of them to be able to get to be leaders of the profession. And that's also the opportunity that students have today.
Thank you so much for that. What such an inspirational message to sort of begin to wrap up on, because I think for myself, and I'm sure many of my colleagues here at the law school, we've been thinking a lot about not only the bar exam, but the future of the profession. And between conversations with professors, employers, clinic directors, we're all sort of thinking about the way that this profession can change and grow to meet the changes and growth in society. And I do not think it would be a shock to anyone to say that the legal profession has turned slowly. And it's exciting to think about and to really see ways in which it can concretely change to better match the world and the society that we're hoping to live in as a community and as a group. And so I really, everything that you and Professor London both just said resonated deeply, and thank you. As I know time is starting to wind down, 2 hours can really fly when you are discussing such exciting things. I want to just sort of take a moment to continue that reflection and think about, what do we all walk away with today? What is the big takeaway in how we can improve lawyer licensing to better reflect this world that we're hoping for and this profession that we're hoping for? What would you consider the biggest thing that we could go out and do today?
Oh,
I,
Zoom pause. Oh no, right? Take it away.
what I was going to say, if my story resonated with anyone, what I would say the takeaway is to persevere. You understand that this was not designed, made in any way for you to succeed, but I am a living example that in due time, being on the other side is much better. So persevere. You started this journey, finish, see it through. And there are many ways that you don't anticipate that it will pay off. So stay true to yourself. Remember the reasons why you started this journey, and persevere, and continue, and just finish.
I totally agree. That's beautiful. One thing I tell my students is this. I know sometimes it can seem like there are so many big issues out there, and how can I, as one person, handle all of my life challenges that I have and also take on the challenges of the profession? And so I always just say, like, one small thing, If you just stand up every day in the profession for one small change, whether it's the way someone speaks to you, whether you are, advocating for someone else, if we all just do one small thing, then it becomes that giant wave, right? So I don't like to think about it as like, I have all this change needs to happen, right? But like tiny, little bit, and right, persevere and never give up, because the law is slow to change, but it will change, right? And if we're all pulling in the same direction, it can't help but not to.
It's interesting because I see parallels to this discussion in all of the other work that I do on access to justice, right to counsel, unfairness in the legal system. Guess what? It's biased against people who don't have power and don't have money. And guess what? There's vested interests who have a stake in the status quo. It doesn't mean they're all evil, right? Who's going to be the agent of change? We talked about that. I mean, think about it. Do we want the oil and gas companies to help us figure out the solution to climate change? Because maybe they could be in the renewable energy business. Maybe they can help a little, but they're going to protect themselves. And so what I feel is so difficult for the students is that it's not fair that it's all landing on you. You should be able to have your life. You should be able to have your career, and you have to have I agree with everything about persevering. You have to protect yourself so that you don't get scarred from this and disillusioned. But I also think you can't just forget. And then once you get over the finish line, this is one of the challenges of licensing, right? The people who are in a power to change it don't have any personal interest in changing it because it worked for them. So you have to not forget. I have students in my public interest law course who decide they can't afford a public interest career who can. That doesn't mean there's no role for you to figure out whether it's pro bono, volunteering, how you vote, how you become an activist. So I think a book like this is incredible because it really lays it out. You don't have to do research for 15 years to figure out what the problem is. It's now all laid out for you. Right? So the question is how you survive and thrive, but then don't forget and figure out a way to agitate and figure out a way to put pressure on the system. It's not okay the way it's working. And right now you may not feel you have power, but you're all going to be in a position where you could have power. So the question is, are you going to remember this conversation and figure out how to use your power for positive change?
That is also beautifully said. So I want to echo the message of each of the messages that you've heard, starting with perseverance and not giving up. And it's exactly correct that one of the problems with licensing is that most lawyers, once they get through it, want to forget about it. It was, for many people, it was traumatic, it was painful. At best, it was a waste. And at worst, it was a crisis for them, right? So once you get through a hazing ritual, your impulse is to put it behind you. And that's the impulse of our entire profession. And that is absolutely one of the explanations for why it has been so bad for so long. And so I guess part of my message would be, take care of yourself. Bring your strengths, all of your strengths, to this process. And then when you are on the other side, remember the people who are behind you and use the power that you will have to make it more fair and thereby improve the profession and thereby do a better job as a profession of actually protecting the public who we are supposed to be protecting.
Thank you all for those beautiful thoughts and inspiring words. I know that I feel fired up to go out and make change, and I'm sure that I am not the only one here who is feeling that way. I feel like there's so few occasions in life where you are told, particularly as a student, as someone who's about to enter their career, now is the time. You have this opportunity to go out and really make these broad sweeping changes for the betterment of your profession and for the betterment of the community that relies on it. So thank you all, genuinely, and from the bottom of my heart, for being here and for sharing this today. As we wrap up, I again just want to say thank you. And if anyone has any sort of final closing thoughts, I would welcome them. But otherwise, I think we can end for today.
Thanks, Julia, and thanks to the Law Review. This has been really a very special opportunity. I'm very grateful.
Keep up the good work.
Yes, thank you so much.
Thank you for this event. Thank you for including us. And again, Dean Howarth, thank you for this book.
Thank
Yes, thank you so much.
you.
This event wouldn't be here without all of that hard work. And for anyone who is a New England law student, the book is available in the library. So please, if you're looking for it, go and check it out. It is truly excellent. So a great read.
Thank you.